Always remember that ignorance of the law is not and can never be an excuse. Let's dive into the Constitution of the Federal Republic of Nigeria as amended. Section 9. Mode of authoring provisions of the Constitution. Section 9, subsection 1. The National Assembly may, subject to the provisions of this section, alter any of the provisions of this Constitution. Subsection 2. An act of the National Assembly for the alteration of this Constitution, not being an act to which Section 8 of this Constitution applies, shall not be passed in either houses of the National Assembly unless the proposal is supported by the votes of not less than 2/3 majority of all members of that house and approved by resolution of houses of assembly of not less than 2/3 of all the states. Subsection 3. An act of the National Assembly for the purpose of altering the provisions of this section, Section 8 or Chapter 5 of this Constitution shall not be passed by either houses of National Assembly unless the proposal is approved by the votes of not less than 4/5 majority of all the members of each house and also approved by resolution of the houses of assembly of not less than 2/3 of all the states. Subsection 4. For the purposes of Section 8 of this Constitution and of subsection 2 and subsection 3 of this section, the number of members of each house of the National Assembly shall, notwithstanding any vacancy, be deemed to be the number of members specified in Section 48 and 49 of this Constitution. Section 10. Prohibition of state religion. The government of the federation or of a state shall not adopt any religion as state religion. Section 11. Public order and public security. Section 11, subsection 1. The National Assembly may make laws for the federation or any part thereof with respect to the maintenance and securing of public safety and public order and providing, maintaining, and securing of such supplies and services as may be designated by the National Assembly as essential supplies and services. Subsection 2. Nothing in this section shall preclude a House of Assembly from making laws with respect to the matters referred to in this section, including the provision for maintenance and securing of such supplies and services as they may be designated by the National Assembly as essential supplies and services. Subsection 3. During any period when the Federation is at war, the National Assembly may make such laws for the peace, order, and good government of the Federation or any part thereof with respect to the matters not included in the exclusive legislative list as may appear to it to be necessary or expedient for the defense of the Federation. Subsection 4. At any time when the House of Assembly of a state is unable to perform its functions by reason of situations prevailing in the state, the National Assembly may make laws for the peace, order, and good government of that state with respect to matters on which a House of Assembly may make laws as may appear to the National Assembly to be necessary or expedient until such time as the House of Assembly is able to resume its functions. And any such laws enacted by the National Assembly pursuant to this section shall have effect as if they were laws enacted by the House of Assembly of the state, provided that nothing in this section shall be construed as conferring on the National Assembly power to remove the governor or the deputy governor of the state from office. Subsection 5. For the purposes of subsection 4 of this section, a House of Assembly shall not be deemed to be unable to perform its function so long as the House of Assembly can hold a meeting and transact business.